Today I'm going to tell you about the United States Bill of Rights. The United States Bill of Rights are the first 10 amendments to the United States Constitution. The first United States Congress, which met in New York City's Federal Hall, was a triumph for Federalists. The Senate of 11 states contained 20 Federalists, with only 2 Anti-Federalists, both from Virginia. The House included 48 Federalists to 11 Anti-Federalists, the latter of whom were from our only 4 states: Massachusetts, New York, Virginia, and South Carolina. Among the Virginia delegation to the House was James Madison, Patrick Henry's chief opponent in the Virginia ratification battle. James Madison introduced a series of constitutional amendments in the House of Representatives for consideration. Among his proposals was one that would have added introductory language stressing natural rights to the preamble. Another would apply parts of the Bill of Rights to the states, as well as the federal government. Several sought to protect individual personal rights by limiting various constitutional powers of Congress. Like Washington, Madison urged Congress to keep the revision to the Constitution, a moderate one limiting to protecting individual rights. Federalist representatives were quick to attack Madison's proposal, fearing that any move to amend the new Constitution so soon after its implementation would create an appearance of instability in the government. The House, unlike the Senate, was open to the public, and members such as Fisher Ames warned that a prolonged dissection of the Constitution before the galleries could shake public confidence. A procedural battle followed, and after initially forwarding the amendments to a select committee for revision, the House agreed to take Madison's proposal up as a full body beginning on July 21, 1789. 17 articles approved by the House August 24, 1789. After the first enumeration, required by the first article of the Constitution, there shall be 1 representative for every 30,000 until the number shall amount to 100, after which the proportion shall be so regulated by Congress that there shall be not less than 100 representatives, nor less than 1 representative for every 40,000 persons, until the number of representatives shall amount to 200, after which the proportion shall be regulated by Congress, that there shall not be less than 200 representatives, nor less than 1 representative for every 50,000 persons. 12 articles approved by the Senate September 9, 1789. Second article: no law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. 12 articles approved by Congress September 25, 1789. Third article: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, of abridging the freedom of speech, or of the press, or of the right of the people, peacefully to assemble and to petition the government for a redress of grievances. 12 articles approved by Congress September 25, 1789. 12th article: the power not delegated to the United States by the Constitution, nor prohibited by the states, are reserved to the states respectively, or to the people. The United States Bill of Rights has little judicial impact for the first 150 years of its existence. In the words of Gordon S. Wood, after ratification, most Americans promptly forgot about the first 10 amendments to the Constitution. The court made no important decisions protecting free speech rights. For example, historian Richard Lembunsky attributes the bill's long legal dormancy to 3 factors. First, it took time for a culture of tolerance to develop that would support the bill's provisions with judicial and popular will. Second, the Supreme Court spent much of the 19th century focused on issues relating to intergovernmental balances of power. And third, the bill initially only applied to the federal government, a restriction affirmed by Barron v. Baltimore in 1833. The First Amendment prohibits the making of any law respecting an establishment of religion, impeding the free exercise of religion, abridging the freedom of speech, infringing on the freedom of the press, interfering with the right to peacefully assemble, or prohibiting the petitioning for governmental redress of grievances. Initially, the First Amendment applied only to laws enacted by Congress, and many of its provisions were interpreted more narrowly than they are today. The Fifth Amendment protects against double jeopardy and self-incrimination and guarantees the rights to due process, grand jury screening of criminal indictments, and compensation for the seizure of private property under eminent domain. The amendment was the basis for the court's decision in Miranda v. Arizona in 1966, which establishes that defendants must be informed of their rights to an attorney and against self-incrimination prior to interrogation by police. The Eighth Amendment forbids the imposition of excessive bails or fines, though it leaves the term excessive open to interpretation. The most frequently litigated clause of the amendment is the last, which forbids cruel and unusual punishment. This clause was occasionally applied to the Supreme Court prior to the 1970s, generally in cases dealing with means of execution. In Furman v. Georgia in 1972, some members of the court found capital punishment itself in violation of the amendment, arguing that the clause could reflect evolving standards of decency as public opinion changed. Others found certain practices in capital trials to be unacceptable arbitrarily, resulting in a major decision that effectively halted executions in the United States for several years. The Ninth Amendment declares that there are additional fundamental rights that exist outside the Constitution. The rights enumerated in the Constitution are not an explicit and exhaustive list of individual rights. It was rarely mentioned in Supreme Court decisions before the second half of the 20th century, when it was cited by several of the justices in Griswold v. Connecticut in 1965. The 10th Amendment reinforces the principles of separation of powers and federalism by providing that powers not granted to the federal government by the Constitution nor prohibited to the states are reserved to the states or the people. The amendment provides no new powers or rights to the states, but rather preserves their authority in all matters, not specifically granted to the federal government. George Washington had 14 handwritten copies of the Bill of Rights made, one for Congress and one for each of the original 13 states. The copies for Georgia, Maryland, New York, and Pennsylvania went missing. The New York copy is thought to have been destroyed in a fire. 2 unidentified copies of the missing 4, thought to be the Georgia and Maryland copies, survive. One is in the National Archives and the other is in the New York Public Library. North Carolina's copy was stolen from the state capitol by a Union soldier following the Civil War. In an FBI sting operation, it was recovered in 2003. The copy retained by the first Congress has been on display along with the Constitution and the Declaration of Independence in the Rotunda for the Charters of Freedom Room at the National Archives building in Washington, D.C. since December 13, 1952. Thanks for watching this Adventurous Kids episode.